my question and really my concern comes from the appointed judges. Can you just explain why every other judge in the state is elected and we've determined that that's reasonable for them to be elected, but in this one instance, we want appointed?
Good morning, everyone. Welcome to Assembly Judiciary. Welcome to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online. And I will open the hearing on AJR8. AJR8 is an Assembly Joint Resolution which proposes to amend the Nevada Constitution to provide for an establishment of a business court. Again, please introduce yourselves and spell your name for the record, and when you are ready, please proceed.
Thank you, Chair Miller, Vice Chair Marzola, members of the Assembly Committee on Judiciary. I am Assemblymember Joe Dalia, Joedalia, representing Assembly District 29 in Clark County. It is my pleasure to be here today once again to present Assembly Joint Resolution 8, which proposes to amend the Nevada Constitution to establish a statewide appointed business court. With me here today in Carson City to present this measure is Professor Ben Edwards of UNLV's William S. Boyd School of Law, who is our state's top legal scholar in corporate law. This resolution is in many ways the culmination of 2 decades of work. Since 2001, Nevada has operated business court dockets in Clark and Washoe counties following a recommendation from the Legislative Commission's subcommittee to encourage corporations and other business entities to organize and conduct business in Nevada, made during the 1999-2000 interim. These dockets, modeled loosely after Delaware's Chancery Court, have greatly improved our state's ability to adjudicate complex business cases and correspondingly our ability to compete with Delaware. However, despite the progress we've made and despite having some very talented judges on the bench right now, our system still suffers from certain structural limitations that put us at a disadvantage relative to Delaware in terms of business court expertise, predictability, and efficiency. AJR8 addresses those limitations by constitutionally enabling the legislature in a future session to establish a statewide business court with appointed judges vetted and selected for their expertise in the relevant areas of business law. This court would exclusively handle intra-business and cross-business cases, such as disputes involving shareholder rights, mergers and acquisitions, fiduciary duties, and other similar business disputes. As Professor Edwards will detail, the potential benefits of this court are massive. Chief among those benefits, this will allow Nevada to compete more capably for the multi-billion-dollar corporate filings market by offering businesses greater legal predictability and efficiency. That in turn could lead to more businesses, particularly technology companies, physically relocating here given our substantial commercial real estate footprint and proximity to Silicon Valley. It will also promote expertise and efficiency throughout our judicial system by preventing the commingling of civil, criminal, and business cases within one judge's docket. Last but certainly not least, in discussions with stakeholders in the venture capital space, we've repeatedly heard that this court will boost interest for cross-state investments in Nevada-born startups and small businesses, fostering much-needed economic growth and diversification coming from our homegrown talent. In sum, the business court represents a very unique and lucrative opportunity for our state that promotes not only the quality of our judiciary, but also promotes some of our most pressing economic goals. With that, I will now turn the presentation over to my co-presenter, Professor Edwards, to provide additional background and walk you through the resolution. Thank you.
Thank you. My name is Ben Edwards, Benedwards, and thank you again to the chair and the members of the Judiciary Committee for considering this issue. I'm a member of Nevada's Board of Finance and a professor of law at the William S. Boyd School of Law at UNLV, where I teach courses on business law. I'm also a co-author of a treatise on Nevada business and commercial law published by LexisNexis and an editor of the National Business Law blog. I'm here to speak to you today in my personal capacity. I encourage you not to hold anything I say against Member Ohrenlichter. Nevada now stands as a leading contender on a short list of recommended states for business creators to use to create their business entities. States collect enormous sums from business entity fees. Delaware, the national leader, now collects over $2 billion in revenue attributable to business formation. In contrast, in 2024, Nevada collected about $211 million from commercial recordings and entity revenue. This number could go up or down depending on how businesses see the relative benefits of incorporating in Nevada against other states. It's my view that we should do sensible things to make that number go up. And Nevada has substantial room to grow. Every time someone decides to create a Nevada entity instead of a Delaware entity, a Texas entity, or a California entity, it creates more revenue for Nevada. The Delaware Court of Chancery drives much of Delaware's popularity because the global business community trusts Delaware courts will always have a sophisticated judiciary able to quickly move cases. This amendment aims to make it easier for founders to pick Nevada with confidence by creating a selection process that will allow outsiders to trust that 15, 20, or 30 years from now, they will have access to a business law judiciary with deep expertise in business law. Delaware knows that its appointed expert judiciary gives it an advantage, and it is watching Nevada closely. Delaware's governor recently warned corporations against going to Nevada and rolling the dice on Las Vegas. Let me quote Delaware Chief Justice Seitz speaking at a legislative hearing in Delaware on February 20th. The Court of Chancery and the Delaware Supreme Court have never been busier. We're deciding more complex disputes with high-profile litigants than ever before. Many of these business disputes are expedited, meaning that the judges have to interrupt their existing work and put expedited cases on the top of their already tall pile. We are unrivaled by any other judiciary in our country with exceptional speed, deciding multi-billion-dollar cases. We are the envy of other states who for decades have tried but cannot duplicate our secret sauce. Don't take my word for it. Here's what the folks that are involved with setting up a rival business court in Nevada said this morning about the Delaware judiciary and the challenges Nevada faces in setting up a specialized business court. And here is where he quotes me within less than 24 hours of publication of something about this resolution. One of the major advantages Delaware enjoys is its knowledgeable, dedicated, and extremely hardworking judiciary. Delaware indisputably has the most case law in hand to answer open questions, but putting that aside, Delaware can also hustle and move on an expedited basis to resolve matters. Without a specialized court with the expertise and bandwidth to move quickly, incorporators may still tilt toward Delaware because their courts can resolve huge disputes fairly swiftly. And wow, does Delaware move quickly? Recent statistics indicate that over 92% of Chancery Court cases are disposed of within 90 days. Statewide, Nevada statistics are not readily available, but a records request to the Judiciary Statistics Department revealed that for fiscal year 24, the average time to disposition for Clark County's business court sat at 1,228 days. Fiscal year 23 was better, with an average of time of 656 days. That's still far too long. Nevada is just not set up right now to keep pace with Delaware courts because judges handling the existing business docket often have other dockets to manage as well. It's incredibly challenging to simultaneously manage a criminal docket, a civil docket, and a business court docket, switching from arraignments to personal injury and then to mergers and acquisitions. This resolution would clear business court judges to focus on business law and get matters resolved. Other states are also moving to compete more vigorously for this business by improving their infrastructure and adopting competitive law. Last year, Texas created an appointed business court. Texas business court judges are appointed directly by the Texas governor and serve 2-year terms. Last week, the Texas legislature introduced a bill copying provisions of Nevada corporate law and making additional changes to compete more effectively. This resolution aims to provide a more stable bench than Texas in 2 ways. First, it calls for judges to be selected from a list provided by a nominating commission with a range of important stakeholders. Second, it sets terms to 6 years instead of 2. This means that Nevada would offer a more stable and predictable judicial environment where the business court's composition will not change on a dime if the party controlling the governor's office changes. With that in mind, here are other key provisions of Assembly Joint Resolution 8 codified by the conceptual amendment circulated earlier. The resolution enables the legislature, to the extent funds are available, to provide for the establishment of an appointed business court. Nevada will always need to balance among priorities. This preserves the legislature's flexibility to appropriate funds where they are most needed should there be a funding crisis after the amendment passes. The resolution outlines the exclusive original jurisdiction of the business court, focusing on complex business and commercial disputes. It also empowers the chief judge of the business court to transfer matters to other district courts should the matter be more appropriately adjudicated by another court. It sets the term of office for business court judges at 6 years without any term limit. The resolution preserves the ability of the public to retain a say in the Nevada judiciary through a retention ballot instead of an election process. The resolution provides for the appointment of a chief judge of the business court by the Chief Justice of the Supreme Court. It makes necessary conforming changes to other sections of the Nevada Constitution to integrate the business court into our judicial system. In conclusion, this resolution modernizes our judicial infrastructure to maintain and enhance our competitive position. However, please keep in mind that this resolution is only a first step. If the legislature approves, and if it is approved in identical form during the 2027 legislative session, the voters will decide the final approval or disapproval in the 2028 general election. Once the legislature gains the constitutional authority to create an appointed business court, it would then need to pass legislation to expend funds and actually establish the business court. Although passing this resolution won't immediately create a business court, it will send a message to the business community that Nevada is committed to creating a stable business environment for the long term. If more startups begin to pick Nevada as their state for incorporations, all Nevadans will benefit from the regular fees they pay to maintain a Nevada entity. This court has the potential to enhance Nevada's economic competitiveness, attract new business, and ensure the swift and expert resolution of complex commercial disputes. I urge your support for this resolution and welcome any questions you might have.
Okay, thank you so much for your presentation. And often as chair, I always have to remind people how to correctly pronounce the name of our state. And it is Nevada, not Delaware. So just wanted to put that out there. So we will begin. We have a number of questions. So the first question will come from Assemblymember Gray.
Thank you, Madam Chair. Keeping in mind we're not a money committee, but the question still remains, who's going to pay for this? Will this be wholly funded out of fees?
So the choice about how to fund this is going to be something for a future legislature to decide. If, as I expect will happen, you continue to see increases in entity formation, there may be significantly more fees being paid to more than offset the cost. The court itself will also be able to charge its own filing fees. I know the Delaware Chancery Court charges well over $1,000 a filing.
Thank you, Professor.
And yes, that decision would be made after it would pass through. Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for answering our questions. My question, and really my concern, comes from the appointed judges. Can you just explain why every other judge in the state is elected and we've determined that that's reasonable for them to be elected, but in this one instance, we want appointed?
Assemblymember Joe Dalia for the record. It's a really good question, and we are supportive of appointed judges in other contexts where it might be appropriate. There's two pieces to this one. One, these are some of the most complicated types of cases that we see, and it's not a normal part of the curriculum. So when you go through law school, you're taught civil law, you're taught criminal law. You are not automatically taught business law. And on the bar exam, you're infrequently tested on business law. Much to the chagrin of my co-presenter who just took the Nevada State Bar, and there was not a corporate law question. So I think in this situation, because these are such time-consuming cases that drag down the dockets of other types of cases as well, there is a lot of efficiency to be had by concentrating these with experts that are vetted for that expertise to make sure that the whole judiciary functions well for all plaintiffs. Does that answer the question?
Thank you. No, I appreciate that. I think that we hear a lot about judges literally having the power of life and death over folks. And so I just wonder, are you saying that our current judges are not capable of making these decisions today?
Assemblymember Joe Dalia for the record. No, we have actually some very talented judges on the bench right now. The issue that we have is that when you have an elected bench, there's no guarantee, there's no set of spots for we're going to elect this many, family law experts, this many experts in personal injury law, this many experts in business law, and that creates an inefficiency that I think that we're trying to fix here. So they are the current business court happens to be staffed by folks that have commercial litigation experience, but that is kind of a product of random chance. If a certain set of candidates just don't run, then we might have none on the bench, and then we're put in a position where we might be educating a judge in real time on a type of law that they're not familiar with, that now they have to adjudicate that type of case. So that's, sorry, does that answer the question? Sorry. Thank you.
So based on that question, I'm going to dig even deeper, because in the bill it says appoint that the governor from among 3 nominees selected for each individual seat by the Permanent Commission on Judicial Selection. So who appoints, or how does one become get on the Commission of Judicial Selection?
Thank you, Chair. Assemblymember Joe Dalia for the record. So we've amended that piece in our amendment language, the friendly amendment language. So now we are going to, other stakeholders expressed a concern about the commission. So what we're planning to do to give more stakeholders a voice in the process is to have a set of, a special nominating commission formed by the legislature. So this would be part of that enabling legislation in fiscal year 2029, or whatever the case may be when this would be passed. And the legislature would then set forth the size, composition, and nominating procedures of that commission. But it would include the Speaker of the Assembly at that time, the Senate Majority Leader, the Chief Justice of the Nevada Supreme Court at that time, and the Chief Judges of the 3 most populous district courts. So that would be likely the 8th, the 2nd, and I assume the 1st.
Okay, so that seems pretty consistent with how appointments occur currently in the state. And then would that be approved through the Ledge Commission?
I think we're open to that. We didn't want to set up too many parameters and hamstring the future session too much, but I think that that's an appropriate venue for that.
Okay, so with that, though, could you still answer to me who currently, how does one get on the Commission for Judicial Selection?
I'll pass that to my co-presenter.
Ben Edwards for the record. The Nevada Constitution currently has an existing judicial nominating process, and it includes, I think, representatives of the state bar, appointees by the governor, and it may not have the same degree of legislative influence as this would, and so there's some, I think, geographic restrictions, but I would have to spend some time specifically reviewing the existing constitutional structure. But the thought is that this alternative structure with a commission selected or created for this purpose is going to work better in the future.
Thank you for that. I was just really trying to get at that it just wasn't another example of just ultimate executive powers. That was just it. Thank you so much. We will move on to our next question. Will be from Assemblymember Roth.
Thank you so much, Chair, and thank you for the presentation. Kind of going off, some of what's been said. So it was mentioned, kind of the commingling of cases right now. Our judges hear a wide range of cases, and I've certainly been in the position where I've educated in real time a judge regarding criminal law matters or something like that. So can you explain why a business court? If what we're talking about is an issue with judges hearing subject matters outside of their expertise, there are many judges who are not experts in civil law or criminal law or anything like that. And so why a business court versus a statewide housing court or a statewide consumer protection court or something of that?
Ben Edwards for the record. So here, one of the reasons for an appointed business court in this context is simply for speed of adjudication. So if you have a large public company that is operating in Nevada and they have a deal that they need to close, they can probably close that deal within 90 days in Delaware. Here, the deal might end up on hold for years, and that's I think a real barrier to selecting Nevada, just in terms of the speed of adjudication. But when it comes to there being benefits to specialized expertise across these other areas, you're absolutely right, and we have family courts established specifically for that purpose. And I would not in any way be opposed to creating other specialized courts, but this, again, my area of expertise is generally business law, and I wanted to stay in that lane.
Thank you for that, member. And while this is still fresh in the air, legal Ms. O'Krent found for us the appointment process for the commission. And so the commission is made up, it's under Section 21. It says the commission is comprised of 2 justices or judges appointed by the Supreme Court, 2 members of the State Bar of Nevada, a public corporation created by statute appointed by its Board of Governors, and 3 persons not members of the legal profession appointed by the governor. So if that solidifies a little more thought to where we're at right now, we will move on to Assemblymember Gonzalez.
Thank you so much, Chair, and thank you so much for the presentation. I was kind of wondering if you could speak to Nevada's capacity for a new court. I think even this legislative session, we've heard of how overburdened the courts are, how they're asking for more judges, and so how does that in tandem, in this conversation?
So Ben Edwards, for the record, in terms of capacity, for a new court, this is something I think the future legislature is going to have to evaluate. One of the reasons we structured it as enabling legislation is to give that future legislature the ability to look at, where the judiciary is right now, the volume of cases going through, and how many, members or seats would be appropriate to create. So in terms of a funding capacity, if the amendment does generate substantially more confidence, in Nevada being a stable and predictable jurisdiction, then funding it may become substantially easier if revenue from entity formation increases.
Member Gonzalez, does that answer your question? Yes, thank you. Okay, thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here. I don't think I need any more convincing of the need of a business court. Having had some presentations and speaking with some judges about, I even have a constituent in another county that is waiting 2 years in civil court on a business matter and has been defrauded millions of dollars and has had to close their business over this whole situation. So I think the need is there. I think we're here to, and at least in my opinion, talk about some of the mechanics, and I like the baby steps about enabling. And I appreciate your memo. That really was good. It was like frequently asked questions, and I'm like, yeah, these are the questions at hand. Along the lines of appointment, because it is a little bit outside of what we do in Nevada, appointing judges, I do get it. There needs to be a real knowledge in this area of business law. So what is I think you mentioned retention ballot. If you could explain that a little bit more. So if we are out of the norm on doing appointments, it seems like our backup then, our safety net, is the retention ballot. So if you could go into that a little bit.
Assemblymember Joe Dalia, for the record. Thank you so much for the question in the comments. So the retention ballot, essentially the way this would function is that the last election held during that judge's term, they would be subject to essentially a yes-no, right? Voters would be able to say, okay, we've heard enough about this judge. Like, I don't know how they're getting through the appointment process over and over and over again, but we have to have some kind of safety valve to get rid of this judge because it's just, we're not ending up in a good place for the state. This gives them the ability by a 51% or a little over 50, right, to essentially send that judge off the bench, right, in which case, but that's all they're doing, right? They're not electing a new judge. They're just pushing that judge off the docket, and then what would happen is there would be another appointment process. So the same appointment process we've been using is just that judge would then not be eligible for reappointment for that posting. So, thank you.
Thank you so much. We will return to Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for the second bite at the apple. So I have another question about you talked about we need to expedite, and people are waiting 2 years to get through, and I understand that, but we've also heard of folks that are incarcerated and waiting to be heard, and we've heard of folks that are waiting for relief and are waiting years and years for relief. And so I just wondered, can you explain why we are jumping businesses ahead of our constituents in expediting their needs rather than trying to expedite those other issues?
So these other issues are critically important. Again, Ben Edwards, for the record, these other issues are incredibly important. And I see your concern. And one of the challenges I think the state faces is always resources and having the ability to have enough judges to handle all the work that's in front of them. So the benefit of an effective appointed business court is that it makes those resources generally more available. Delaware gets over $2 billion a year in entity fees. It is also my understanding that the judiciary is also coming to you and requesting more judges to handle that workload. This, to some extent, would simply be a reorganization of existing dockets. If judges that are currently handling a civil docket, a criminal docket, and a business court docket, if some subset of them switches exclusively to business court, then those things that are clogging up the other dockets and slowing down relief, like these complex matters, once they're moved to their own forum, they don't slow down other matters, and so this is an efficiency measure. But generally, I am not at all opposed to devoting more resources as well to making it easier for people to get relief in a timely manner. I think it's important.
Thank you. We will also return to Assemblymember Roth.
Thank you so much, Chair. My question is more practical, and maybe you can walk me kind of through the practicality of this is, correct me if I'm wrong, this is enabling language. And so let's say everything goes as planned and a business court is set up and it's filled with judges who understand the complexities of business law, and it brings in an influx of businesses into the state of Nevada. And then we hit a recession, and the enabling language, we now no longer have the funds to fund a business court because we need to put the constitutional rights of our most vulnerable citizens before our corporations, right? So then what happens to those cases? Does the business court just dissolve? Do those cases now, with an influx of businesses, go back to the district courts where they're going to have issues handling that influx? Like, what happens if we reach that scenario?
Assemblymember Dalia, for the record. So just to clarify the question, is the question that if we've already funded the startup costs of the court and then something happens before the next biennium to continue funding the court?
Correct.
Gotcha. Well, in this case, once we've established it, it is established. It'd be like any other district court, right? But I don't envision a scenario, in speaking to stakeholders, the demand for this is overwhelming. And we expect that this is going to, even the passage of this in the process of moving it towards making this a permanent measure, we're going to see an uptick in Secretary of State filing fees. And if that number goes down marginally because we experience a recession, we can't get ahead of that, but we don't ever anticipate a point where the continuing operations costs of the court are not met by its own filing fees and by those Secretary of State fees. We expect that to be covered by an exponential figure. So, thank you.
Sure.
Do we have an actual estimate of what we're going to be bringing in?
Assemblymember Dalia, for the record. We have a ballpark, so we can kind of situate it between, we're at $200 million right now. $2 billion is Delaware's share. In stakeholders we've talked to, we don't want to be overly optimistic in our estimates, but we've been told that folks expect this to be in the hundreds of millions to the low billion figure for annual new revenue from just this piece. Thank you.
Quickly.
I'm just wondering, I'm just trying to get to, like, is this evidence-based? Like, where are these data points coming from? And is this based on actual, like, data that we have in the state of Nevada, not based on what we're seeing in Delaware? Because it's apples and oranges, right?
Assemblymember Joe Dalia for the record. I do think that they are apples and apples, because what Texas and Delaware have done relative to what we're doing, it is all kind of the same thing. In terms of having a figure that we could point to as this is the exact sum we're going to have coming in, short of getting companies to sign a binding contract to agree to come here, I don't know how we could get there, but we do have enough folks in that industry that are telling us that they will start advising their clients to set up shop in Nevada because of this. And you can kind of expand out from that and see that if we can continue to make inroads in that market, and that market is so substantial that it is in the multiple $billion, the estimates we're talking about seem very reasonable. Thank you.
Thank you. We have a question from Assemblymember Urick.
Thank you, Chair, and thanks for this very informative presentation. I think my question aligns more probably on trying to get clarification on an issue, and that is, from sitting here listening to the questions and the answers and the presentation itself, it seems less about prioritizing Nevada's business needs over all other criminal and civil litigation matters. But yet it seems to be directed at targeting what is taking up a massive part of our court's dockets in these complex litigation matters. And by removing these and assigning them to where they can be tangentially adjudicated more efficiently, at the same time, it would also free up court's dockets to address in a more timely manner the remaining part of their dockets. Can you clarify that for me, please?
Ben Edwards for the record, and yes, that is a large part of the benefit of this. That by shifting them to a specialized forum, they come out of the space where they're at right now, taking up substantial time. I know for myself, when I teach a class the first time, like my dean made me do with property a few years ago, it takes a lot more work to get up to speed and ready to do it. But when you're doing it all the time, you just become so much more efficient. It's one of the reasons we have siloed out, justice court, family court, and I think there are real efficiencies to specialization.
Thank you for that. Our final question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So my question is, as we all know that there's a need for growing business and this can help in that need. So suppose we have the courts and we have the judges, and my question is regarding that the nomination process, why it has to be nominated, why we cannot go through the election to make it more fair and unbiased?
Ben Edwards, for the record. The challenge with an election process is that you are not always going to be able to guarantee to outside stakeholders that the people who are winning those elections are the ones that that have the expertise. I know from my own experience, voting for judges, I'm very well positioned to be able to figure this out, in that I'm a law professor. A lot of the judges are adjuncts, at the law school. Many of my students go on to clerk for them. And I still am calling around, expending an enormous amount of effort trying to figure out who to vote for in a contested election. And so the challenge is that there's just no way to give clear assurance that the people who are going to win those elections are going to be people with substantial expertise in this particular area of law, and that's the goal, is to ensure that expertise sits on the bench.
Thank you.